You're watching a judicial nominee refuse to say whether he agrees with pardoning people who beat up police officers, then claim he can't answer because of judicial ethics, even though judges don't have pardon power. Then another nominee can't tell a senator whether her own social media posts were facts or opinions. Senator Hirono just asked nominee Mr. Ricky if he agrees with Mike Davis's statement that January 6 defendants suffered enough and deserve pardons. Ricky says he doesn't recall liking that post. Hirono says she has the receipts. He did like it. So does he agree with the pardons? Ricky pivots to talking about the president's plenary authority to pardon. Hirono cuts him off. I'm not asking about the president's powers. Do you agree with the pardons? Ricky says answering would violate judicial ethics canons. That's not how judicial ethics work. Judges don't pardon people. Saying whether you think pardoning people who assaulted police is appropriate isn't commenting on a case you'd hear. It's stating whether you believe violent crimes should have consequences. Then nominee Camp can't answer whether her tweets about senators were facts or opinions. Hirono asks repeatedly. Camp talks about retweeting people she doesn't know. Hirono asks yes or no. Were your posts facts or opinions? Camp says she shouldn't have retweeted. That's not an answer. What you're about to hear is how judicial nominees dodge basic questions by claiming ethics rules that don't apply, and why inability to distinguish fact from opinion matters when you're being confirmed to find facts.
Okay, I start all of my questioning by asking a fundamental question of all of the nominees to any of the committees on which I sit. So I'll ask this panel, and we'll start with Ms. Clark and go down the line. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
Senator, I have not.
No, Senator.
No, Senator.
No, Senator.
Have you ever faced discipline or entered into a settlement relating to this kind of conduct?
No, Senator.
No, Senator.
No, Senator.
No, Senator.
I have a question for Mr. Ricky. On social media, you liked an article in which Mike Davis said, and I quote Mike Davis, "I have no problem with President Trump pardoning almost all of those January 6 defendants because they've suffered enough." Now, you posted that you like that, so I want to ask you, do you agree with those pardons? Do you agree with the sentiment that they've suffered enough?
Senator, I don't recall liking that particular article. I do know the article that you were referring to, however. And what I would say on that is that the Constitution gives the president plenary authority to issue pardons. And as
no, I'm not asking about what powers the president has. I'm asking whether you're telling me that you don't recall liking this post by Mike Davis.
That's correct, Senator. I don't.
You made the post. So now, as you sit here, and I'm telling you that this is the information I have, that this is factual, that you like that post. Well, do you agree with the pardons?
Senator, when it comes to the pardons, but the point I was making is that given that the president has this plenary
I know
authority.
that. You don't need to sit there and lecture me about the powers of the president. I would just like to know whether you agree with those pardons.
As a nominee to serve on the court, I believe it would be contrary to the canon of judicial ethics for me to comment on the president's pardon power. And so respectfully.
Well, you are, as a judge, you will not be having any pardon power. So if confirmed, will you hold all criminal defendants accountable under the law, regardless of their political affiliation?
Yes, Senator. If I'm fortunate enough to be confirmed, any criminal defendant who comes before me after
It's
having.
pretty clear that the president pardoned 1,500 of the January 6 defendants based on ideological reasons. And yes, the president has very wide-ranging pardon powers, but he pardoned 1,500 people, many of whom beat up Capitol Police. It's just amazing to me. Ms. Westerkamp, you did not hold back, and you were asked by my colleague about some of the posts that you put out regarding various members of the Senate. You did not hold back. Now, you would consider those posts opinions, not fact, I hope.
Senator, I believe some of what Ranking Member Durbin referred to were retweets. And again, I think retweeting from other people whom I don't know about people or controversial topics is improper to
Anyway,
do.
okay, my question is that, so you posted things that you, of people you didn't know, including me, by the way. So I'm just asking whether you understand the difference between these posts, which were not facts, but opinions. Were they your opinions?
Senator,
Everybody's entitled to an opinion, so are you.
Senator, I do understand the difference between an opinion and a fact.
Okay, so those are opinions.
Senator, again, using social media as Senator Kennedy has said.
Yes or no, you cannot sit there and tell me whether the posts where you put out posts relating to members of the Senate, that whether those were facts or opinions. You can't tell me that.
Senator, I should not have retweeted, and retweeting from other people should not have done that, and if confirmed, would avoid.
I'm asking, excuse me, I am asking a yes or no answer, and the fact that you can't, to me, those are opinions. And of course, judges are supposed to be the finder of fact. They're supposed to be the people who should distinguish between fact and fiction. I do have a question regarding when you were, I believe you advised the president on trade matters, including tariffs, I take it.
Chairman Grassley, I'm out of time, but would you like?
I'm sorry, I didn't hear you, yes?
She asked the question before her time was up, so whatever time it takes for you to answer, you've got.
Oh, I'm so sorry, I was just on a roll here.
No, you properly
Well,
answered.
I will submit for the record a question I have about her role in providing advice on trade policy, which the Supreme Court has said that President Trump's tariffs are illegal.
Senator Brett.
What happened in that hearing wasn't just evasive testimony, it was a demonstration of how judicial nominees use ethics rules as shields to avoid accountability for their views, and why that matters when those views directly relate to their fitness for the bench. If you understand what questions were asked and what defenses were offered, you'll see how confirmation hearings become exercises in non-answers dressed as principle. Start with the pardon question. Senator Hirono asks nominee Ricky if he agrees with pardoning January 6 defendants who assaulted police officers. This is a straightforward question about whether violent crimes should have consequences. Ricky first says he doesn't recall liking a post supporting those pardons. When Hirono says she has evidence he did, he pivots to talking about the president's constitutional pardon authority. Hirono cuts through this. She's not asking about presidential powers, she's asking if Ricky personally agrees with pardoning people who beat up cops. Ricky's answer is that commenting would violate judicial ethics canons. This is false. Judicial ethics prevent judges from commenting on cases they might hear or on pending litigation. But this isn't a case. It's a policy question about whether pardoning violent offenders is appropriate. Judges express views on criminal justice policy all the time in confirmation hearings, academic writings, and public speeches. The canon doesn't prohibit having opinions about whether crimes should be punished. It prohibits prejudging specific cases. The distinction matters because Ricky is using a misapplication of ethics rules to avoid stating whether he believes assaulting police officers should result in legal consequences. That's not judicial neutrality. That's hiding behind procedure to avoid revealing values that might disqualify him. If he thinks people who committed violent felonies suffered enough through prosecution and deserve pardons, that view suggests he might be lenient toward politically motivated violence. That's relevant to fitness for the bench. Then there's the fact versus opinion question with nominee Camp. Hirono asks repeatedly whether Camp's social media posts about senators were facts or opinions. This isn't a trick question. It's asking whether Camp understands the fundamental distinction judges must make constantly. What is factual assertion versus what is subjective judgment? Camp can't or won't answer. She says she retweeted people she doesn't know, that she shouldn't have done it, that if confirmed she wouldn't do it again. But she won't say whether the posts were facts or opinions. This matters because judges are finders of fact. They assess evidence, determine credibility, and distinguish between what happened and what people think about what happened. If a nominee can't clearly state whether her own statements were factual claims or subjective opinions, how will she assess that distinction when parties present competing evidence in court? saying I shouldn't have posted it, doesn't answer whether you know the difference between fact and opinion. It just says you regret the political consequences. The retreat to I retweeted people I don't know is particularly revealing. Camp posted content about sitting senators. Whether she authored it or retweeted it, she endorsed it by sharing it. Saying she doesn't know the original sources doesn't absolve responsibility for amplifying claims. And more importantly, it doesn't answer whether those claims were factual or opinion-based. A judge who can't categorize her own statements as fact or opinion is either unwilling to answer or unable to make the distinction. Either is disqualifying. The pattern across both exchanges is the same. Use procedural deflection to avoid substantive answers. Ricky hides behind judicial ethics that don't actually apply. Camp hides behind regret about social media use without addressing the underlying question about her analytical capacity. Both strategies work because confirmation hearings don't require answers. Nominees can filibuster, claim ethics constraints, express regret, and run out the clock without ever stating their actual views or demonstrating basic competencies. What makes this particularly troubling is that these aren't complex legal questions requiring nuanced analysis. Do you think people who assaulted police should be pardoned? Is a straightforward moral question. Can you distinguish between fact and opinion in your own statements? Is a basic cognitive test. The inability or unwillingness to answer either suggests either unfitness or calculation that honesty would prevent confirmation. The judicial ethics misapplication is worth emphasizing because it's become a standard confirmation dodge. Nominees claim they can't answer questions about policy, values, or legal principles because of ethics rules that actually only restrict commenting on pending cases or likely litigation. This allows them to appear principled while avoiding any meaningful inquiry into their judicial philosophy or fitness. And because senators can't compel answers, the dodge succeeds. If any of this concerns you, recognize that confirmation hearings only work if nominees answer questions honestly. When they hide behind inapplicable ethics rules or refuse to categorize their own statements, they're not protecting judicial independence, they're avoiding accountability. And when that avoidance succeeds and they get confirmed anyway, you learn that stated qualifications matter less than political support in determining who gets lifetime appointments to interpret the law.